All right, our first topic in today's video is ADR. And so what exactly is ADR? Well, it stands for Alternative Dispute Resolution. And it's basically any method of solving a dispute without actually going to court, without litigation. And so according to the Office of Justice program, which is actually a part of the U.S. Department of Justice, only about 3% of civil cases reach the trial verdict. And this basically means about 97% of cases are resolved using other means, other non-trial means, without actually going to court. So why would somebody want to use an ADR rather than just going to court traditionally? Well, for one, it could be much less expensive, and it's probably going to be faster than the traditional court system, because they will usually leave you waiting months and even years for your case to be fully resolved. Some people might like the private aspect of an ADR, and it gives each party more control over the outcome as it's not decided by that third party. And the three topics that we're going to be covering in today's video are going to be negotiation, mediation, and arbitration. The first topic we're going to cover today is negotiation, which is the most informal type of ADR. Negotiation is basically just a discussion between two people in hopes to reach an agreement by the end of it. There's no judge, there's no mediator, no third party involved in the discussion. It's just between the two parties. And negotiations are usually used in smaller everyday disputes and very minor instances where you don't want to get a third party involved in it. People like to use negotiation because it's simple, it's quick, it's free, and again, nobody else has to, become involved in the situation. It just stays between the two parties. This gives the most control to each party over the outcome of the situation as well, which is definitely a benefit. In some situations, using negotiation, it might not be the best idea, as clear communication is required between both of the parties. So if that's not there, negotiation might not be the best ADR to use. Many times having a third person present could help guide the discussion in the right direction and help reach a better outcome faster, or just a better solution overall. Emotions, they could run high when people are trying to negotiate, as each person is really trying to get the best deal from themselves. So having a third party present to keep everybody grounded is not the worst idea for some specific situations. And that will take us right into mediation, which is basically a more organized version of a negotiation with that third party. A mediator is the third party that is there, and they are there to help try and guide the conversation. Basically, they're there to help try to find a common ground between both the people and come up with a clear and fair solution for both parties. The thing about a mediator is that they do not make the final decision at all. They are not the ones that make the binding decision. The parties do. They are there to just influence the decision and help the two parties come to that resolution at the end. The good thing about mediation is that it still encourages people to solve these disputes outside of the court system. And that might be hard for some people, as mediation really requires both parties to be cooperative with each other still. And, that might be hard in some instances like divorce, child custody, landlord-tenant issues where mediation is more commonly seen. The next type of alternative dispute resolution we're going to look at is arbitration. And arbitration is sort of like litigation in a way, as it's sort of like a private judge. I like to think of mediation and negotiation similarly, and, litigation and arbitration very similarly. They act as a private judge, and they are able to call awards and make final binding decisions. Again, everything is done outside of the public courtroom. So typically, these things will go a lot faster using arbitration. And, keeping them private for both parties will definitely benefit people who have maybe a public image, or people that don't want their court cases being fully public, but still want that full binding decision from a judge. There are two different types of arbitration that are most commonly used, and they're binding and unbinding. So binding basically means that it's a final decision and you cannot go to a court to appeal it. It is fully final. And arbitrators are allowed to give those out. But a non-binding decision, you can go back and try to appeal it through a regular court or whatever you do please. Arbitration is definitely a good middle ground that could be used. It's definitely easier and faster than normal litigation through the courts. But it is more structured than regular mediation, as the third party does make the final call. The one drawback that is definitely most common is that the costs add up very easily when it comes to arbitration. They're very, very expensive to hire the private judges, and you will most commonly see these in more higher status cases. To wrap this all up, negotiation, mediation, and arbitration all help people avoid the time, cost, and the stress of going to court. And ADRs are widely used and sometimes even required by courts. And again, negotiation is the most informal type of ADR, and it's just the discussion between both of the parties directly. Mediation is where a mediator helps guide the discussion and parties make the outcome. Both parties still make the outcome. And the arbitration is where an arbitrator hears the case and makes the full binding decision. That is the difference between negotiation, mediation, and arbitration, and that is the summary on ADRs, which is alternative dispute resolutions. Thank you.